Hello everyone, let's discuss today's The Hindu editorial page. The first article is Centralized Procurement as a Powerful Health Idea. In this article, the author suggests that a centralized procurement team could be more effective in addressing the issues of price and quality in the Indian healthcare sector. The author also questions why hospitals should be different when it comes to drug procurement. In India, many countries and international organizations have shown that a pooled buyer model for drug procurement addresses many issues related to price efficiency, stockouts, and quality concerns. However, the central government often ignores the merits of pooled procurement when it comes to schemes like the Central Government Health Scheme, CGHS, the Pradhan Mantri Jan Arogya Yojana, PMJ, and the Employees State Insurance Scheme, ESI. The author's paper, A National Cancer Grid Pooled Procurement Initiative India, demonstrates the viability of such an idea, revealing the advantages of group negotiation in pooled procurement for high-value medicines. This approach can be applied to other health systems besides cancer. In conclusion, the author suggests that the central government's inconsistent approach to healthcare procurement could be a solution to these issues. The next article is Demolishing the Frame from Outside the Constitution. In this article, the writer says that the recent chilling effect in India has been a significant development, with the Delhi police conducting extensive raids on NewsClick, arresting 2 individuals, including its founder and editor-in-chief, Prabir Purkayastha, in cases that have invoked the Unlawful Activities Prevention Act. This action raises serious questions over the erosion of freedom of speech and expression, which has been widely commented upon. The media fraternity has responded by writing a letter to the Chief Justice of India, D.Y. Chandrachud, urging him to take judicial notice of the matter. The logic may be that a Supreme Court of India that gave India the basic structure doctrine in an attempt to restrict majoritarianism running roughshod over fundamental rights has crossed a line. The question of what the extent of a court's reach should be in a democracy has gripped legal scholars for centuries. As an unelected institution in a system with an elected legislature, courts have taken the role of protecting the democratic process very seriously. Courts have an obligation to ensure that the integrity of the democratic process is protected, as if the democratic process is faulty. There is ample scope to raise questions over the rules and values that govern a society. In conclusion, the recent developments in India have raised concerns about the erosion of freedom of speech and expression, the role of courts in protecting the democratic process, and the potential for a broader trend of violence and demonization against religious minorities. The next article is from the Hindustan Times newspaper, Invoking the Spectre of Judicial Legislation. In this article, the writer says that the Supreme Court, SC, has passed 2 significant judgments in India, rejecting a woman's request to terminate her 27-week-long pregnancy and rejecting all the prayers in a batch of petitions seeking marriage equality and a bouquet of rights for the LGBTQ+ community. Justices Ravindra Bhatt and Hema Kohli held that an entitlement to a legal union of marriage and a legal framework for queer couples could only be granted through a law enacted by Parliament, not by the judiciary. They said that all queer persons have the right to choose their partners, but the state cannot be obliged to recognize the bouquet of rights flowing from such a relationship. Chief Justice D.Y. Chandrachud broadly recognized civil unions and the right of queer couples to adopt, but both concurring dissents stopped well short of marriage equality owing to institutional limitations. All 5 judges agree on one thing, that the courts do not have the jurisdiction to legalize same-sex marriage, since to do so would amount to judicial legislation. Thus, the provisions of the Special Marriage Act, 1955, SMA, and Foreign Marriage Act, 1969, that restrict marriage to a union between a man and a woman were upheld. In parliamentary democracies, legislatures work on the principle of majoritarianism, which is why courts of law are vested with the power of judicial review to protect the citizen majoritarian interests and the interests of so-called minuscule minorities. In the case of the queer petitioners, they wanted legal and social recognition of their partnership, stability, and certainty from having a recognized bouquet of rights of adoption, inheritance, insurance, tax benefits, and the ability to open joint bank accounts. However, the government took the view that recognizing marriage equality would undermine the social fabric of the institution, and impact the safety and health of the children that were conceived of such unions.